Morning. Well, I'm not a little bit. No. I'm usually pretty good about saying that around here. Hearing State of Michigan Court of Claims is now in session. Presiding the Honorable Seema G. Patel. All persons having business here in draw their attention and they shall be heard. God save these United States, State of Michigan, and the South.
Good morning, everyone. Calling case number 24-000165, Michigan Republican Party versus Benson. Can I have the parties put their appearances on the record for me?
Morning, Your Honor. Brandon Debus. Morning, Your Honor. Brandon Debus here on behalf of the Michigan Republican Party and Clerk Cindy Berry.
You.
Good morning, Your Honor. Jonathan Koch on behalf of the Republican National Committee.
Good morning.
Morning, Your Honor. Daniel Ziegler on behalf of the Michigan Republican Party and Cindy Berry.
Good morning, Your Honor. Assistant Attorney General Eric Grill appearing on behalf of Secretary of State Jocelyn Benson and Director of Elections Jonathan Brader.
Morning. Did you want to put co-counsels?
My associate here is not yet admitted, so he will not be
Oh,
here.
okay, great. Well, welcome, gentlemen. It's good to see everyone. Miss Buzelli, did I say your name correctly? Oh, Teresa Roberts. I'm sorry. I was told that Natalie Buzelli was Miss Roberts. Thank you very much for being our court reporter. I'm going to ask everyone to be mindful of giving your argument today so that Miss Roberts can get the argument down and not have to pull her hair out trying to follow you along. So with that, we are here on everyone's cross, the defendant's motion for summary disposition, as well as plaintiff's cross motion for summary disposition. We'll start with defendant's motion. Let's go ahead. And I think when we do the argument, we'll argue because there are interrelated issues, argue both together, and I'll give both sides time for rebuttal as well. So with that, let's get started.
Morning, Your Honor.
Morning.
In this case, the plaintiffs are requesting, the plaintiffs here are the Republican National Committee, the Michigan Republican Party, and the Chesterfield Township Clerk. And they are requesting a declaration that the spouses and dependents of military and overseas voters should not be allowed to vote. That request is, according to the complaint and to the response brief, based on a Yahoo News article in which a political action committee is quoted as saying they anticipate or they expect that 80% of overseas voters will cast their ballot in favor of the Democratic Party. Whether what that statement is based on, whether it's accurate or not, who can say? But regardless, that is an extraordinary claim for extraordinary relief. And it is all the more extraordinary coming 28 days before the election and challenging an instruction that has existed consistently since at least 2017. It could actually go beyond that. That's only the earliest version of the manual we've been able to lay hands to. Such an extraordinary claim should be accompanied by extraordinary legal support, but in this case, there is none. As an initial matter, and first, the plaintiffs waited far too long to bring these claims. And whether you're considering that under the Court of Claims notice requirements or under the doctrine of latches, this case is simply far too late. This instruction, again, has existed consistently since 2017.
What about the plaintiff's argument, especially with regard to standing and the Court of Claims notice requirement that the claims didn't accrue until voting began?
Respectfully, Your Honor, there is no legal authority to support that, and it's also factually wrong. I'll begin by that logic, that would suggest that any of the rules in the election manual that address election day would not be capable of being challenged until election day. That simply makes no sense. Maybe that's the plaintiff's theory and belief, and maybe we can look forward to some claims being raised on election day, but I think that's all the more reason to say now that that is not the way that this works, and these claims need to be brought well in advance of the election so that people know the ground rules before we start counting votes. The purpose of the doctrine of latches is to avoid last-minute changes to election rules, which is exactly what the plaintiffs are requesting here. I'll also point out that the plaintiffs are simply wrong about the time that they've chosen. September 21st is not the first day for overseas ballots. It's the last day. It's the deadline that by that point, you have to have already sent out your absentee ballots to overseas voters. So their ballots were going out in advance of that time. So 21st was not the day. And then lastly, even if we could get to the idea that the 21st was the date of accrual, this lawsuit was filed on October 8th. The affidavit attached from Cindy Berry is dated September 26th. So if the idea was we're going to wait and see if she's going to actually apply these rules, which I don't think is really a good faith argument, because once the manual is published, there's a pretty good indication that we're going to be applying these rules as they were applied in the August primary and as they were applied in the presidential primary in February. Same rules were applied. But if you're going to go by the 21st, why wasn't this case filed on September 21st or the 22nd or the 23rd? There was an extraordinary delay even after the time that they've chosen. Any way you look at it, the plaintiffs are way too late coming to this court. Now, since there's really no question that the plaintiffs have delayed bringing their claims before this court, their arguments concerning prejudice fare no better. The plaintiffs argue that the other cases that they've raised this year, challenging portions of the manual, that they resulted in changes to the manual. So that's not really any problem, right? The problem is that there is a problem. There is a difference between a claim that is raised in August and a claim that is raised for the first time in October. The forward passage of time means something here. We are currently today just over 2.5 weeks away from this election. People are already have already received their absentee ballots. They are already returning their absentee ballots. This election is underway. And this lawsuit comes at a time when it is simply too
Do you
late.
have a number for how many absentee ballots have been received by the clerks at this point? I
There
know,
was in the affidavit attached to our brief, there was an affidavit from Jonathan Brader, which I believe had that number. 1 second, Your Honor. On page 6 of Director Brader's affidavit, paragraph 22, he states that Michigan currently has 16,600 military overseas voters. And then I believe later on here, as of September 30th, this is paragraph 28 on page 9 of the affidavit,
111,000.
611,000 have already been returned out of 2 million ballots that have already been issued. So, and of course, that was already 2 weeks ago. People continue to return ballots apace. Now, what is also striking about the point when the plaintiffs filed this lawsuit was that it was done over a week after Judge Schwartzel's decision on October 3rd, stating that the claims raised in a complaint filed in September were already barred by latches, that they had been raised too late for the department to effectuate any changes to this election cycle. And then a week later, after that order, the plaintiffs filed this new action. Honestly, Your Honor, it's hard for me to understand exactly how the plaintiffs don't think we were prejudiced. There was already a determination by Judge Schwartzel in that case that there would be no relief for this election cycle. And the plaintiffs here in this case in their response brief say that they think that Judge Schwartzel's approach was correct. Well, I think that's an astonishing concession.
I didn't look at this beforehand. Are any of those cases making their way up through appeals processes or
None.
no? Okay.
I don't believe, and counsel can correct me on that, but none of them are currently on appellate review. But that again, of course, it fits into the problem, Your Honor, when we're talking about appellate review. Whatever determination this court makes today, if either party seeks an appeal in this matter, we're less than 2.5 weeks away from the election. What is
Why I
it?
set the hearing so quickly.
Correct. And I think the court has done everything it can, but there's just limits to what can be done for a lawsuit filed this late in the game. As we raised it in our motion, there's actually a statute that says that there's a presumption, a rebuttable presumption of latches that applies to election cases that are filed less than 28 days.
This one was filed right on the 28th
right on
day?
28 days, Your Honor, which is hard not to accept the conclusion that was knowing.
Was it end of day, the 28th day?
I believe it might have been the morning, Your Honor, but in either sense, it's the day of. So clearly there's already been a legislative determination that we are in the window of time where this really should not be happening. The plaintiffs in their response note that Judge Schwartzel did order a minor change to the manual, and I want to address that very briefly just to point out that the change that was made was a change effectively of one word, and all that it did was to conform the instruction to what was already happening. We weren't being required to change or put in place a new process or a new procedure, and that's significant because that's exactly what they're asking us to do here. This is not a case where they're just asking us to tweak or adjust the language. They want these voters to have their ballots rejected, which means we would have to develop a process to identify, remove, and disqualify those ballots.
Could you, speaking about the process, could you provide some just education about what that process is? What information the Secretary of State receives versus the local clerk's office receives, especially when because I was looking at I want to get the verbiage right, the federal postcard?
The postcard, correct,
Yeah.
Your Honor.
So where, like, how does that information, does it ever translate into the qualified voter file? Where is that information kept? Is it siloed with the local clerk's office? Does it ever reach the Secretary of State's office? Anything that you can provide guidance on that in terms of,
I've done my best to try to understand that, Your Honor. There is some limits to my understanding, and, obviously where we are, I'm not in the best position. We don't have a discovery record in the background. I can refer to the record, but it's my understanding that the postcards are sent by the voters and they are then sent to their local clerks. I do not believe, at least I have no information, that there is a process for those postcards to be forwarded on to the Secretary of State. When we're talking about the postcards, it's been a point in the plaintiff's response that, well, there's a checkbox that says, I have never been a resident. All you would need to do is look for that checkbox, and that's our voter. That's who we're going to pull out. That's not correct. Respectfully, they're reading the postcard wrong. What the postcard says, and even according to the graphic they've included in their response, it has a list of several boxes, and it says on the instructions for the card, pick one. The second box says, I am an eligible spouse or dependent. That's the box that these voters would choose. There would be no reason to continue to go on down to, I have never been a resident of the United States. It's useful, I think, to remember that this is a federal form. This postcard is a federal document, and that they are dividing their forms to appeal or to apply to a variety of jurisdictions, some of which treat military and civilian overseas voters differently. That's not what we do here. So as a Michigan voter or a Michigan voter abroad that would read that postcard, they would see, I am an eligible spouse or dependent, check the box and stop. So we do not have the ability to rely on that I've never been a resident checkbox. At best, it would produce inconsistent results that some people.
because you're saying that somebody who has never resided in Michigan and is not give me an example of a citizen who would be eligible to vote, but is not a child or spouse of a
I'm not
overseas
sure.
serviceman.
I had the same question. I'm sorry. I apologize.
An overseas serviceman or woman.
I apologize, Your Honor. It wasn't my intention to cut you off. I had the same question because it's not an obvious question answer of, well, wait a minute, if there's spouses and dependents, check the second box, who would check the last box? And it's not entirely clear. Like I say, this form is for all the states, and it may be that another state that treats their civilian voters differently than their military voters, that would then be an applicable box for them.
Maybe children of diplomatic personnel who are not necessarily service members, but
Not necessarily service, could be civilian, embassy, staff or family members. But I think that still there's a chance that if I'm a child of an overseas voter that's eligible, that is a registered overseas voter, I'm a dependent of that overseas voter, I might be inclined to check the second box and think that my job is done. And that might be different in other states, but certainly in Michigan, under the terms of 759A3, that say a spouse or a dependent of an overseas voter is allowed to register whether or not they've ever been a qualified voter in Michigan. So to my mind, I would see that and say, I'm an eligible spouse or dependent. Check the box and move on. Maybe some people check the I've never lived in Michigan box, but it certainly would not be the kind of thing that would be conclusive and reliable enough to say that these are the voters who are ineligible, and so therefore we will reject their ballots. It's at best an inconsistent application and setting us up for other problems. Ultimately, what this leaves us with is chaos, confusion, disruption, and again, none of this would be necessary. If these claims had been raised earlier in the year, even last year, we would have had the opportunity to litigate this matter. We could do some discovery. We could make it a conclusion. We could implement a proposed remedy well in advance of the election. And we could even have the opportunity for full appellate review with oral arguments and briefing and the whole regular ordinary course of litigation. There was absolutely no justification for the delay here, and that delay has had sorely prejudicial effects on the defendant.
I have one other question, sort of stemming from this. We talked a little bit about the processes and the fact that there's some ambiguity about what those processes are. For the secretary's position, I'm guessing since you filed a motion for summary disposition, you think that the issues can be decided as a matter of law.
Yes.
Do you think that there is any discovery or evidentiary matter that needs to be settled before the court can fully resolve the issues
I guess
presently before it?
nothing is immediately apparent to me. I guess, if the court feels there's something that the court needs to understand in terms of the prejudicial effect on the defendant. Because I think really, the first threshold that we have to get over here is whether or not there is even an opportunity for the court to reach the merits. Whether the doctrine of latches, if nothing else, prevents any further review or analysis of this matter just because it is no longer appropriate, no longer possible to offer relief. And again, I would note that the director of elections has signed an affidavit saying that he has concluded it is not possible to effectuate the relief, and the plaintiffs have offered absolutely nothing to controvert that.
Because going off of Judge Schwartzel's analysis from a few weeks ago, he bifurcated it, right? He said that the doctrine of latches applies as applied to this election cycle, but left open the issues for future cycles. Do you think that that is necessary here, or can the issues be decided as a matter of law here?
I don't think it's necessary. Certainly, it would be an opportunity available to the court if the court thought that there's a meritorious claim that we're not going to decide it for 2024, but we're going to investigate and look at this, and we're going to make a more deliberative approach toward 2026 and beyond. The court could consider that. I think that if the conclusion is that these claims are barred by latches, then perhaps that might be the best way to do it, and we can deal with future elections because it's always possible that statutes, laws, whatever change between now and even 2026. But it certainly is something I think the court has available to it at its disposal if it feels, if nothing else, that we shouldn't be changing the election rules for this election 2.5 weeks ahead of time. I also want to point out that when we're talking about the idea that we're going to select out these ballots from these spouses and dependents who have never lived in the United States, and we're going to pull them out and reject those ballots, that is a systematic process of removing ineligible voters. However, the plaintiffs want to frame it, there's no other way to describe it than a systematic process. That is certainly what the Department of Justice would call it when they say that we're violating the NAVRA, the National Voter Registration Act, by conducting a general program to systematically remove a specific type of voter 2.5 weeks before an election. But somehow, if we were to get past all of the procedural hurdles, the standing Court of Claims Act, latches, and the court reaches the merits of the plaintiff's claim, the claims are simply devoid of any legal merit. They premise the entire complaint on the Constitution, Article 2, Section 1, and the part of the Constitution that they thought this claim was based on, they italicized it. I think it's paragraph 3 of the complaint. They say the 6 months, who has resided 6 months in the state of Michigan. They italicized it. That's what they thought this was about. But that 6-month requirement hasn't been the law in Michigan since 1972, at least since 1978, when then Attorney General Frank Kelly opined that it was no longer valid in light of the U.S. Supreme Court's decision in the Dunn case. I would also note that while the plaintiffs argue that, well, no Michigan court has ever actually determined this to be invalid, perhaps not, but it's been 50 years and no one's even thought to bring it up. I would also note that in the District of Connecticut, the District Court for the District of Connecticut, there was a case in 1972, just after the Dunn case, where the court found that the 6-month durational residency requirement of Connecticut was so obviously unconstitutional that the state's defense of that provision of their constitution was frivolous in 1972. It was frivolous then, it is frivolous today. Now, instead, the plaintiffs have, in response to our motion for summary disposition, tried to move the goalpost to change their arguments into something else that, well, it's not the 6-month residency requirement, although I think they haven't fully abandoned it, but they are certainly moving away from it, which I think is an indication of the weakness of the claim. Instead, they argue that, well, there must be some residency requirement, some occupation of Michigan. Well, the problem with that argument is the very last line of the very last sentence of Article 2, Section 1, which says that the legislature may define residence for voting purposes. It doesn't say for local voting purposes, it says for voting purposes. And so what has the legislature done? The legislature passed 759A3, which expressly provides for a spouse or a dependent accompanying an overseas voter abroad to be able to use that overseas voter's residence for the purposes of their registration. Now, there are requirements for this. It is not an open waiver. It is a definition. To be eligible for this type of residency, you must be an American citizen. You must be a spouse or dependent. They must be accompanying a military or overseas voter abroad, and they must not be eligible to vote anywhere else. If you meet those requirements, you are considered a resident. And this is not that's no different really than for the entire the conceptual premise of all military overseas voters, that they're not physically here anymore, but we consider their last residence here to be their residence while they are abroad. It's the same type of conception. But nonetheless, plaintiff's complaint does not challenge the constitutionality of 959A3. It's nowhere in the complaint. So even if the instruction were struck, the clerks would still be bound by the statute, which says that they have to accept these registrations and they have to allow these voters to vote. So ultimately, the relief the plaintiffs seek of striking this instruction would have no real effect. It would have no meaning, no application other than changing the language of a manual and forcing the Secretary of State to undertake a new process that isn't supported by law or constitution. Lastly, the plaintiffs argue the defendant's instruction itself is invalid because it doesn't conform to the statute. In this part, they're referring to the idea that, well, the instruction doesn't talk about accompanying, and it talks about children, not dependents, and that's a different thing. Again, the complaint itself did not attack the language, the inclusivity or under-inclusivity of the instruction. It just said it was outright invalid. So this part of their response in this argument that there is a textual deficiency of the instruction is not in the complaint. And it was raised for the first time in response to our motion for summary disposition. So I think it's a little late in the game to be adding a new claim. Regardless, these arguments, like the others, have no merit. The instruction is explanatory. It does not have to only repeat the statute. The Supreme Court said as much in the O'Halloran decision that these explanatory instructions are something that are used to help explain or provide clarity for the clerks. They are not limited only to the words of the statute. Accompanying, the word accompanying, is not something the clerks need explained to them. It's pretty clear from the face of the statute. You have to be accompanying the overseas voter.
I have a couple of questions on the instructions themselves, and there's a little bit of gap between the language of the statute and what the instructions state. They're not exact mirrors. And so with your example of the accompanying the overseas voter, is there any process or procedure, like what is in place to ensure that the spouse or dependent is accompanying the overseas voter? Like, do they have to submit the application with the overseas voter? Do they, like, what does that mean?
Yeah, I don't have that information in front of me, and I don't want to misstate it. Like, I believe that there is certainly there's, I think, if nothing else, like anything else, when you register to vote, you make the representations on the form. I meet these criteria, so you have the representation of the voter themselves. If they don't, if they're not accompanying, then that is the same thing as saying I live at 123 Main when I live at 428 Oak Street. If you make a false statement on your application, then that's something else entirely.
That would be voter fraud.
That'd be voter fraud. And that's certainly always, that's whenever it's found, that is to be punished and remediated. But we're not talking here about a specific circumstance. They have come forward with no actual individual case of a voter doing that. This is all of voters abroad who claim are their spouses or dependents should not be allowed to vote if they have not separately established their residence. And that's again, simply not required. In regards to what means accompanying, the instruction again it's meant to explain the statute. It's not meant really to repeat it. The statute, of course, controls. So if there's any gap between the instruction and the statute is what guides and controls the clerk's conduct. And again, if there is any type of question Clerks call the Secretary of State's office all the time and ask for clarification. What does this mean? I've got a voter with XYZ situation. What should I do with this? And again, there has been no particular factual showing here. This is a facial challenge that the instruction on its face can never be applied. And I don't think there's anything that supports that. Likewise, the distinction that the plaintiffs seek to draw between whether the instruction says, well, it's a child, not a dependent, and dependent means you actually have to be a dependent, not merely be the offspring. And like, again, I think it's pretty clear from the context of the instruction that we're talking here about people that are accompanying, that are residing with, that are dependents. So I don't really think there's anything there particularly ambiguous. But again, the statute would control, and the statute says exactly what it says, that you have to be accompanying the military overseas voter. With that, Your Honor, plaintiffs knew at the time they filed this lawsuit that it was late. They knew at the time, they should have known at the time they filed the lawsuit that this part of the Constitution they were citing to was no longer active or applicable. And it certainly had every opportunity in the world to investigate and verify their claims before filing it. They clearly did not. They investigate and verify their claims before filing, and I think it's clear that they did not. And instead, I think the claims here are harassing, vexatious, and certainly frivolous. And so we would invite the court to apply sanctions for the filing of this action at this stage.
Okay, thank you for your argument. I will allow rebuttal later.
Thank you.
Good morning, Your Honor.
Morning.
I, like most of the other individuals in this room, if not all of them, am a Michigan resident. And for that reason, I will be casting my vote in Michigan. That is how our democratic system was designed, and that is how the Michigan Constitution was drafted. All Michiganders, no matter their politics or their beliefs, cast their electoral votes together based on the outcome of our general election. And it is for that reason that our right to vote in Michigan is limited to Michigan residents. It is of no moment whether you reside in Russia, Canada, or Ohio. If you are not and have never been a resident of Michigan, you may not vote here. Much ink has been spent.
Isn't that contrary to what the statute actually says in terms of defining?
The federal statute, sorry, Your Honor.
No, the Michigan statute.
The Michigan statute speaks to spouses and to dependents. It makes no mention of whether or not you have ever resided in Michigan, and it certainly makes no mention of whether you have never resided in the United States.
Okay.
Much ink has been spent by the Secretary framing this lawsuit as anti-military or being antagonistic to our armed forces and their families. But nothing could be further from the truth. If you are a Michigander and you are serving your country overseas, you are still a Michigander, and your vote is both proper and welcomed here. But that is not what the Secretary is doing with her election instructions. Rather, the Secretary seeks to undo the residency requirement altogether and permit people who have never lived in the United States and therefore have never lived in Michigan to vote in Michigan.
How does your argument square with MCL 168-759A?
I'm referring to that statute, subsection 3, which says that a spouse or dependent of an overseas voter who is a citizen of the United States is accompanying that overseas voter and is not a qualified and registered elector anywhere else in the United States may apply for an absent voter ballot, even though the spouse or dependent is not a qualified elector of a city or township of this state.
Correct. How does that not mirror the 4 requirements that the Secretary of State's instructions have put in place for an overseas voter who is a spouse or a dependent, but has never resided in Michigan to meet the residency requirement?
Well, I would say that there is a distinction. This statute does not say has never been a resident of the state of Michigan. It's speaking to the local residency requirements. At least that's what it appears to be. And there are additional requirements. For example, there's no doubt that I'm a Michigan resident. I've lived here my entire life, but I am about to move. And when I move, I'll be
Doesn't
going.
subsection, I'm sorry, doesn't subsection 4 then state that the address provided on the voter registration form is the residence of the registrant?
It does say that, Your Honor. But I think that we still need to comply with the Michigan Constitution, which said that you need to be a resident. So for example, if you are qualifying under the
Back
statute,
to the Michigan Constitution. I said, going back to the Michigan Constitution, the Constitution states that the legislature shall define residence for voting purposes.
and then I think now we need to get into textual interpretation. And so we have the requirements, every citizen of the United States, 21 years of age, we know that that's been changed to 18, who has resided in the state 6 months and who meets the requirements of local residence provided by law. Textually, grammatically, provided by law only applies to who meets the requirements of local residence. And so we have our Michigan legislature defining by law, not really defining by law, but addressing by law the local requirements for local, or the requirements for local residents.
What is the canon of statutory interpretation that supports your reading of the Constitution that way?
I believe this is the last antecedent rule. And that qualifier and where it appears in the sentence would only apply specifically between the commas and the requirement that it appears next to.
And what is the whole text canon? How does that interplay with the interpretation of this provision?
I don't believe I understand the question. I'm sorry.
What about the whole text canon?
In terms of reading the entire text in harmony. So I think there, again, we can look to whether you are a resident for 6 months in the state of Michigan, for some amount of time, you are a de facto resident, and whether or not you meet the requirements of local residence. Clearly, there are two separate requirements. And again, I am a Michigan resident. I do not meet the requirements to be a local resident in Metro Grand Rapids or Metro Lansing or the Upper Peninsula. So I can't vote there. I can certainly vote in Michigan. I vote in my precinct and in my local area where I meet the local requirements as provided by law. But that doesn't mean that I don't have to be a Michigan resident. So under this statute, this Michigan statute, it says, okay, if you are an otherwise qualifying person, i.e. a Michigan resident or were, you're overseas because you're a spouse or a dependent, whether or not you're going to meet those local requirements, whether it's a durational requirement or the fact that you have moved, we're going to waive those. We will use the address that you put down on the form, which could be your spouse or your parents. But you still have to, at some point, have been a Michigan resident to vote in Michigan.
Okay.
So I think we've essentially addressed the merits of the Michigan Constitution.
I have a question just in terms of how, if I were to take your analysis to its logical conclusion, how do you respond to defendant's argument that you've, in essence, disenfranchised an entire group of citizens who otherwise would be eligible to vote from being able to cast their vote anywhere in Michigan or in the United States?
Well, Your Honor, if you are a United States citizen who never resided in the United States, well, the Michigan Constitution defines who gets to vote in Michigan. And so if you're not associated with the state, we know that you cannot vote in Michigan. That does not mean that you would not qualify to vote anywhere else. So if you are, I suppose, a stateless person who never resided anywhere and is not qualified to vote in any state that has this requirement, well, then maybe we have a problem for the federal government to address. But we need to look at the Michigan Constitution and what it says. And it says no Michigan resident, no contact with the state, no voting here. Perhaps, I don't know, I did not do a 50-state survey on every state's constitution. Perhaps there are other states that would allow, under these circumstances, to vote there, and that would be a place that they could take advantage of. Perhaps the District of Columbia is an option. But again, if you are a United States citizen living abroad who have never resided in the United States, I believe that would be for the federal government to address. And they had an opportunity with UOCAVA, and it's very specific that you have to otherwise qualify from your state. It's specifically for people who are in the United States who leave the United States to be overseas or to be expatriates or what have you. It's not for people
Regardless
who have
of the
never been
fact that
here.
you're a citizen of the United States whether or not you get to exercise your fundamental right to vote or not is not Michigan's problem.
Michigan's problem is for Michigan residents. And I think that's exactly how our system was designed. So I would certainly never argue that a United States citizen should not be allowed to vote. But for the same reason I would vote that an Ohio citizen doesn't vote in Michigan. If you've never resided in the United States, you've never resided in Michigan. Perhaps there's somewhere else to vote, but it's not here.
Let's turn to the latches argument that is raised by defendant, because I think that might be your biggest hurdle here.
So certainly this instruction has been in place for a long time. But I do think that it is important to point out that the application of the instruction matters. Brother counsel mentioned that September 21st isn't the right date. He said it was before that. Well, when before that? The deadline to certify ballots, I believe, was September 6th. So we're not talking about the passage of months and months and months. And if it took a little bit of time to notice how this unconstitutional instruction was being applied, we acted immediately. We acted diligently. This was not an intentional or strategic delay. There would be no purpose for doing that because it is a hurdle and we understand that and we want it corrected. But there are two elements to latches. It's an equitable doctrine. Delay is not just enough. So while I would say that we did not delay, certainly not intentionally and certainly not
Well,
unduly.
even through your pleadings, there is a certain reason for the. Anyway, go ahead, please.
Prejudice. I think prejudice is where we should likely focus our argument. The secretary is framing this as being a new process, something that cannot be done. There's an affidavit from Director Brader saying that there is no way to even determine who is not a United States citizen. Well, we've made this argument in our briefs, but I'll make it again now. The application, the ballot itself has the checkbox number 4 that says, I am a United States citizen. I've never lived in the United States. The response to that was to point out the other checkbox, which says I am active duty, uniformed services, merchant marine, or I'm an eligible spouse or dependent. That tracks the federal statute UOCAVA. That's the reason that exists. And even if we look at the Michigan statute, it doesn't say spouse or dependent, or sorry, if we compare it to the secretary's instructions, it does not say spouse or dependent. It says parent, spouse, guardian. So any individual who spent their entire lives outside of the state, outside of the United States, certainly outside of the state of Michigan, would qualify under those instructions simply because mom or dad lived in Michigan or last voted in Michigan or last resided in Michigan.
That tracks with 759A, correct?
Not just for children. It tracks with the idea of potentially being a dependent. And again, we need to make the distinction that 759A does not say never lived in the United States. But we can't expand this to all children. My great-grandmother lived to be 106. So my 85-year-old grandfather.
I mean, I know it doesn't explicitly say that, but we can, through logical deduction, kind of assume that it does, right? Because it says, is not a qualified and registered elector anywhere else in the United States. So if you're not a qualified elector anywhere else in the United States, that means that you've never established a residency anywhere else in the United States, because we know you're a citizen of the United States.
Well, I think that would depend on reviewing every single state's requirements for being a qualified elector.
Well, those
And
are
I'd
set by
imagine-
federal statute, right? Or in federal constitution. Yes, ma'am. That's set by federal constitution and statutory requirements, correct?
The ability to vote in the United States or the ability to qualify as an elector in your given state?
The constitutional right to vote as a citizen of the United States.
I would agree with you. There is a constitutional right to vote as a citizen of the United States.
Okay, and how does that flow? Where do you get that right?
So that would flow from the United States Constitution, your God-given right, so to speak, of being a United States citizen. But
And-
that isn't, apologize, it did
No,
not
go
mean to
ahead.
interrupt. That is an overarching right, and it is less specific than what the states are doing. So it doesn't say you have a right to vote anywhere in the United States, regardless of where you live. I mean, if that was the case, we could
Oh.
have a federal statute that says you pick. If you've spent your life overseas and you've never been in the United States, spin a wheel that lands on whatever state you want and cast your ballot there. But there's no law that says that. So we have to look at what's the most authoritative, most clear text for the state of Michigan, and that's the Michigan Constitution. And it's very clear, 6 month residencies, and we can argue or address whether or not 6 months would withstand constitutional scrutiny.
Let's please address the Dunn case and its application here.
So the Dunn case came out in the wake of the federal statute, which was 52 US 10502, which said that for president and vice presidential elections, you cannot have a durational residency requirement. So this instruction, one, applies across the board. It is not just for presidential and vice presidential elections. And our presidential and vice presidential elections are not limited to just the president and vice president. But we can also say that while it may have gotten rid of durational residency requirements in this very specific instance, which is presidential, vice presidential elections, it does not get rid of a de facto residence requirement. And there are other Supreme Court decisions that have upheld the idea of having de facto residence requirements.
Is that an issue of law for me to determine?
Whether or not a de facto residence requirement is constitutional. So I don't think that it is for this court or this case to determine that affirmatively. I think we need to interpret the Constitution in a way that is harmonious and that avoids constitutional conflict. And so if we say, we know that 60 days, or sorry, we know that I believe it was 1 year in that case was too much. And we know that for presidential and vice presidential elections, durational is too much. We avoid that by saying, okay, well, maybe it doesn't need to be for an amount of time, but it still has to exist, right? That would be the avoidance interpretation of the statute that avoids a constitutional conflict. And so I believe that's the proper way to look at it if we are going to limit it to presidential and vice presidential elections, but it is not limited. It applies across the board. And for state, local, even congressional, other federal elections, durational requirements are okay. Now, we could argue about whether 6 months is too much in that instance, but we know that 30 days was enough or was okay. And so there is, I guess, a spectrum of how much of a duration may be too much. But again, if we are going to only peel off the things that we think are unenforceable or unconstitutional, we're still left with a de facto residence requirement in the state of Michigan. And where were we? Believe we were talking about prejudice in the laches context. And I just want to make this point. On this form, individuals check for themselves. Brother counsel said, our process is to believe the voters. Well, perhaps we should believe the voters here. They check the box saying, I'm a US citizen, but I've never lived in the United States. We know at bottom that those are individuals who didn't live in Michigan. And so those votes should at least, in the very least, be segregated and counted and accounted for. That can be done as they come in. It can be done electronically for the ones that already came in. These are Scantron documents. I have to imagine that data exists and is already tabulated. This is not a large burden, and I don't believe it needs a new process. Perhaps it needs a couple more keystrokes. But in terms of implementing a large burdensome process, I don't believe that's the case. I don't think there's any merit to that. And in the very least, as Judge Schwartzel recognized, we can change these instructions. If the determination is that the instructions are in conflict with the Constitution, or if they went beyond the Michigan statute in terms of overseas ballots, well then, again, a couple keystrokes, a couple minutes. I think the point was made that one word was changed in Judge Schwartzel's case. We're asking to change a few. It really doesn't make a material difference on the burden. It can be done the same day. It should be done the same day. And so in terms of laches, even if there's delay, I don't think that they can validly argue prejudice here. And there are certainly, I believe, as you pointed out during Brother Counsel's argument, there's potential to bifurcate if we need to to address the instructions and then address the effect or the process that may need to exist. But that doesn't mean that nothing can be done.
Speaking to that issue, I'm guessing since you filed a cross motion for summary disposition, you think that I can address the issues raised in the complaint as legal issues on the merits at this juncture? Or do you think that there is any outstanding evidentiary issue that needs to be addressed?
I think it can be ruled on as a matter of law based on pure statutory and constitutional construction. The words in the Constitution matter. This court is certainly empowered to interpret those and to issue a ruling on what those mean and whether or not they conflict with the instructions.
Thank you.
Thank you.
Are you finished with your argument for now?
Yes, Your Honor.
Okay. I will take rebuttal arguments. Or are you going to argue next? Okay, well,
I object to that. There was only one complaint and one brief filed in silence.
that is true. I'm going to allow the argument just in the spirit of having plenary argument at this very expedited hearing. And I will allow you plenty of time for rebuttal.
Good morning, Your Honor.
Good morning.
Nice to see you again. So I always try to be brief, and I'm gonna try to be brief here because I'm not gonna try to rehash everything my brother counsel said. So I want to address the argument that Dunn negates this element of the Michigan Constitution entirely. I do not think that is correct. I think Dunn made clear that it was focused on it held that a 1-year durational residency requirement violated equal protection because it sliced and diced between different categories of bona fide residents. They held that a 30-day registration period, which is effectively a 30-day residency requirement, was acceptable. And in the opinion, the court made clear, we emphasize again the difference between bona fide residence requirements and durational residence requirements. We have in the past noted approvingly that states have the power to require that voters be bona fide residents of the relevant political subdivision. Footnote 7, a state may require voters to be bona fide residents. The very next year in Marston v. Lewis, 410 U.S. 679, the Supreme Court upheld a 50-day durational residency requirement. Similarly, in Burns v. Fortson, 410 U.S. 686, the court also again upheld a 50-day durational residency requirement. So clearly something can survive. Maybe it's not 6 months, maybe it's not 3 months, but something can survive of that.
I'm going to ask the same question that I asked your brother counsel, which is, do I get to decide that as a matter of law?
I'm not trying to ask you questions, but just so I understand,
Sure.
Is your question, can you decide whether the U.S. Constitution permits the Michigan Constitution to impose
Whether the 6-month whether the 6-month requirement in the Michigan Constitution passes U.S. constitutional muster, one, and second, ancillary to that is, do I need to reach that issue to address the issues in your complaint?
I believe the answer to both questions is yes. Yes, I believe you are in a position and capable, it's not the right, you have jurisdiction to decide whether something from that residency requirement survives federal constitutional muster. I can talk about more cases. I could brief that. But I think that, yes, that is an issue that you have jurisdiction to decide. And I think that, presuming we get to the merits of that case, yes, I think that's something that you need to decide. And I think that I would analogize this. I would analogize what's the exact words of the Constitution? Who has resided in this state 6 months. I would analogize that to the words of the Constitution, who has attained the age of 21 years. Clearly, people who are 18 to 21 can vote in Michigan because the Constitution says that you can. So even though the federal Constitution extends the franchise to 18-year-olds, that doesn't negate the 21-year-old age requirement. It limits it. It cabins it off to the constitutional limits. And I think the residency requirement does the same thing. And just to belabor the point, Holt Civic Club v. City of Tuscaloosa, 439 US 60, says that no decision of this court, the Supreme Court, has extended the one man, one vote principle to individuals residing beyond the geographic confines of the governmental entity concerned, be it the state or its political subdivision. On the contrary, our cases have uniformly recognized that a government unit may legitimately restrict the right to participate in its political process to those who reside within its borders. That case cites Dunn. So it recognizes that residency requirements generally survive Dunn. Let's see, where do I want to go there? I think on the merits, that's, excuse me. As far as the interplay of 759A3 and the Constitution goes, I think a colorable reading of sub 3, I think the accompanying language matters. I mean, all the words matter, of course. Accompanying means going with. Normally, if I move outside of Michigan, I don't get to still vote here. If I take up residence in Ohio, don't know why I'd do that. Sorry. I don't get to still vote in Michigan if I've changed my residence to Ohio. So normally when you move, that affects your ability to vote. When I moved from Ypsilanti to Grand Rapids, I don't still get to vote in Ypsilanti local elections. So I think that UACAVA and 759A and 168.11.2 recognize that when someone moves overseas for reason of national service or otherwise, we don't penalize that person because they're not moving somewhere else in the United States, right?
Doesn't your interpretation penalize the spouses and dependent children who may have been born overseas and matured, reached age 18 overseas? Doesn't it penalize the children of overseas service people?
I don't think I would use the word penalize, right? I mean,
Your word. But sorry, go ahead.
fair enough. I think the Michigan, and it's going to be the same answer that my brother counsel gave. The Michigan Constitution restricts it to Michigan residents. Defining what that means, if you do not, it precludes not people who have never resided in Michigan, wherever they reside, be it overseas or Wisconsin or Ohio. It does not extend the voting qualifications to individuals who have never resided here. And so I think that the language of sub 3, a spouse or dependent of an overseas voter who is a citizen in the United States is accompanying that overseas voter. Accompanying means to go. I think that that's just clarifying that when a spouse or a dependent who was a Michigan resident and their spouse, their military or overseas spouse moves overseas, they similarly keep their residence for where they previously resided. They get to kind of keep it. I don't think that this statute clearly reads as extending this to people who have never resided here in any way, shape, or form. Let's see, I think that do you have any more questions on the merits? All right. To go to latches, I agree with my brother counsel why I don't think latches applies here. I would offer the, I think, alternative argument. I think that, as even I think opposing counsel appeared to acknowledge, I think he said, if we had brought this suit longer before the election, there wouldn't be the same sort of prejudice. Okay, well, then I would commend Judge Swartzel's opinion. If there's prejudice before November 5th, it evaporates on November 6th. So I think that there is, at minimum, something survives. And in response to the argument that, well, we haven't challenged MCL 168-759A in our complaint. Okay, well, then we'll seek leave to amend. to raise that challenge. And because again, I do think that the distinction between child and dependent is important. Words matter. And I think the requirement that what it means to accompany someone is another issue that will need to be addressed. Because I do think that distinction matters. I think, at this point, I think we fully briefed the other issues. Any other questions?
No, not right now.
Thank you very much.
Thank you. We're going to take a short recess before I hear rebuttal arguments. Thank you.
All right.
We're in here. Got it right in front of me.
They're coming out soon, right?
Oh, yeah, it's always like right
Like right
at,
around-
Thank you. Welcome back. Calling again, case number 24-000165, Michigan Republican Party versus Jocelyn Benson. We'll take rebuttal argument now.
Thank you, Your Honor. A few points I want to raise in response to Brother Counsel's argument. So as I hear their argument, it sounds like they're trying to argue that the Dunn case did not, in fact, overturn Michigan's 6-month residency requirement. There is a problem with that line of reasoning, though, and that is that this would not just apply only to overseas voters. If Dunn doesn't invalidate Michigan's 6-month residency requirement, then that means it applies for everyone, all voters, not just the overseas ones, which would, I think, come as a surprise to a great number of people, because that's not the way that this has been operating since 1978. Regarding the plaintiff's interpretation of Section 759A3 and the idea that this only applies to spouses or dependents who have resided in Michigan themselves, the problem with that interpretation is that it makes the statute redundant. If they resided in Michigan themselves, then they would be their own UOCAVA voters. They could apply as an overseas voter for themselves. They wouldn't need to accompany anyone. So their reading of the statute effectively makes that a nullity. Turning back to the language of the instruction itself, and regarding the term accompanying, the instructions say that the applicant has to have a parent, guardian, or spouse that was last domiciled in Michigan. In that context, has, the idea of having a parent, guardian, or spouse, that references the accompanying part. So it's not absent, it's drawing off of that and saying, if you are accompanying, if you have a parent, that's the way that that instruction reads and is readily understood. Brother Counsel argued that they're only interested and they're only addressing voters who are not associated with Michigan. And I think that belies a fundamental misunderstanding here. These voters are associated with Michigan. They are accompanying their spouse, their parent abroad while they are serving in the military or serving abroad as part of their job duties in some other capacity. Their only reason for being abroad is to be with their family. Mr. Koch, I think, visibly struggled with the idea of in the court's question of what about the children born of a military member abroad? Because there is, I think, a visceral understanding that that results in an unfairness. It's not their fault that they're abroad. They're living with their parent. Their father is stationed at Ramstein Air Force Base or wherever. That's why they're abroad. And that is why the legislature passed 759A. It was a recognition and a way to treat these voters as it is not absolving them or waiving a residence requirement. They are residents. They are determined that if you are an American citizen accompanying an overseas voter who is not otherwise registered anywhere else in the United States, you are resident of Michigan. And I think that's also the problem with their interpretation of Section 2 of Article 2, Section 1. Brother Counsel refers to the language that Constitution. Right after the who has resided in the state 6 months and who meets the requirements of local residents provided by law, and they focus there on the provided by law, and they say, well, that's a modification of local residents, and so that's all we need to talk about. Well, again, I draw the court's attention to the last sentence, which says that the legislature shall define residents for voting purposes, not for local purposes, not for 6-month purposes. They can define residents for voting purposes, all voting purposes. And that's exactly what they did with 759A3. You are a resident if you meet these criteria. And I want to turn back now to the question of prejudice. The argument that, well, we can segregate these ballots. It doesn't really require all that much. We just pull them aside and we set them aside and we treat them differently. Well, respectfully, Your Honor, there is nothing that happens in elections that just happens on its own. All of these things have to be written down in as much detail as we can. because there are always disputes and there is always confusion. Right off the top of my head, sitting here today, I have to ask myself, how would we even do this? What is the process by which we would identify and segregate these ballots out? Who would do this? What would be the error check protocols in place to make sure that we're getting the correct people? Where would these ballots be kept? How would they be marked? I can sit here and probably spend the next hour thinking of really good questions about how this would all work, because there is absolutely no precedent for this. There is no process we can borrow from. There's nothing we can do. We would have to make it up entirely from scratch and then tell the clerks how to do it. We are 2.5 weeks from this election. If latches doesn't apply now, I don't know when it ever would. With that, if the court has any questions, I'm happy to answer them to the best of my ability.
I have no questions. Thank you very much. Now, is one council going to do rebuttal, or are you going to have both? Okay.
Thank you, Your Honor. I think that we have sufficiently addressed the merits and the statutory interpretation. I don't think I heard anything new that was not already addressed in our opening arguments. So I will just address the point about prejudice. I think it's important to note that these are electronically reviewed and tabulated documents. The data exists. And so while certainly someone would have to do something to access that data, we're not asking for a brand new bespoke process to be put in place to segregate and tabulate or invalidate. The data exists. And so the remedy exists. Perhaps there's more process or more questions to determine the proper remedy. But if we're saying keep track of the data so that it can be addressed, well, I don't think there's any prejudice to that because it's already being kept track of. And that's all.
Okay. With that, I wanted to thank both sides for the expedited briefing and argument on this very important issue. And thank you for being here. I want to thank the court reporter as well. Thank you very much for your services. We really appreciate it, Ms. Thomas. And Ms. Roberts, I'm so sorry. With that, we will be adjourned.
State of Michigan Court of Claims now, so